Hello, ladies and gentlemen. Welcome to this Guildhall Chambers webinar on challenging director remuneration. What's in a label? This webinar is part of Guildhall Chambers' series of webinars on insolvency matters, which we have been running during the recent pandemic. By way of housekeeping at the start, could I please invite all of you who are participating in this webinar to mute your microphones and to switch off your cameras. Microsoft Teams has a chat function, and what we invite you to do, please, is to use the chat function to raise questions for your speakers today, and we will endeavour to get to those during the end, certainly, but if there's an appropriate moment during the course of the webinar. Let me just introduce myself and my co-speaker. My name, for those of you who don't know me, is Stefan Ramel. I am a barrister at Guildhall Chambers in Bristol. I practice in the commercial and insolvency teams, and I've done so for more years than I care to remember. My co-speaker today is a colleague in Chambers whose name is John Churchill. John is a member of the insolvency teams and a comparatively recent addition to Chambers, having been in practice for some 3 years, and he tells me that he's been involved in lots of directors' duties claims, mainly on the instruction of the official receiver.
Good morning.
In terms of what you can expect to hear today, this is what we have on the menu for you. I will start off by going through a couple of key principles to set the scene and add a bit of context to the talk and to get you thinking of those matters ahead of the 3 cases that we're going to go through to. So in terms of what we're going to cover today, we propose to go through the key principles I was just outlining, and then to look at a trio of recent decisions, all of which concerns employment benefit trusts and were attacks by liquidators, or in one case the company, to the viability of those. John, my co-speaker, is going to address you on implement consulting before I speak to you about Vining Sparks, and then you'll hear from John again on the issue of Chalcot Training Limited. And then we'll wrap up with some conclusions at the end of the webinar. Let me go through then the key principles that I wanted to talk about, and we thought this would be a good place to start this webinar as a way of setting the scene. As we're going to see in due course, whether you're representing the insolvency practitioner or the respondent directors, in our view, getting the line of attack right is going to be critical, and vice versa. If you're representing the directors, getting the line of defence right is also going to be critical. We think that in order to get to that point, it is first necessary to address some important issues of characterisation. And what we're going to do, of course, is look at them from a legal perspective, not an accountancy or tax perspective. Of course, the context of the relevant case you're dealing with are going to be important, and usually the issues for characterisation will fall in 2 categories. The first one is to correctly identify the nature and identity of the recipient, and the second one is to look at the nature of the transfer of value. As regards the first point, the individual, it might be easy to assume that anybody who is a director of the company is also an employee and vice versa. But a word of caution from the Court of Appeal in Ranson Computer Systems PLC. The Court of Appeal makes clear that simply because a person is a company director does not make that person an employee, rather they are the holder of an office. And moreover, nor does appointment as a company director of itself bring into being any form of contract between the director and the company. Many directors will have contracts of service, but not always. As the Court of Appeal points out, they are distinct but different legal relationships. Let me move on then to outline a couple of these points that we wanted to talk about. First of all, identifying the recipient. Well, the categories are fairly obvious. It could be an office holder such as a director. It could be an employee. The person could be a worker. The person could be a shareholder. And it might be thought that, in fact, it's relatively easy to do that in all cases. But to take one example from my own practice, and it concerns identifying a shareholder, the particular case I have in mind involves payments to various individuals who may or may not be shareholders. And it isn't easy to determine whether they are because, for example, a company's statutory filings, whether it's annual returns historically or its confirmation statements, may not dovetail with what's stated in the company's accounts or the company's share register, if you even ever get to see the share register, which certainly in my experience is a document which is not usually included in whatever papers make their way to the office holder. So characterising the nature in which the person was acting when they received the payments is not always as easy as it should be, but it is an important starting point. So far as remuneration for directors, well, it could take, for example, the form of fees, particularly in the case of non-executive directors, or it could be a salary fixed, for example, in a services agreement, if you're lucky enough to be in a case where there is a service agreement which fixes that. However, that's to ignore certain other aspects of the law. Table A, Regulation 82, says that for the remuneration of a director to be by way of fees, it has to be done by ordinary resolution of the company. And unless the resolution provides otherwise, the remuneration accrues from day to day. Now, model articles will, of course, confer the power to determine remuneration on the board of directors. Standing back, if there is no such determination and there is no service agreement, in the absence of that, there is no entitlement to remuneration for the director, whether as a quantum merit or otherwise, as illustrated recently in a case which started in Bristol before our Chancery judge called Global Corporate and Hale, and made its way up to the Court of Appeal, a case in which the proper characterisation of payments made to an individual who was a shareholder and a director was an issue. Loans I don't need to say terribly much about. Safe to remind you, of course, that the Companies Act in section 197 makes provisions for the approval of loans by the company by ordinary resolution. And similarly, in terms of the definition of the loan, if I can borrow from the case, the judgment of Mr. Justice Walton in Champagne Perrier-Jouet and H.H. Finch Limited, it involves a sum of money lent for a time to be returned in money or money's worth. In other words, a consensual transaction. I suspect that all of us on this webinar are familiar with directors' loan accounts. In my own experience, they're rarely accompanied by explicit approval under section 197. And moreover, the idea that a director consensually agrees to return the money, having received it and having been treated as a loan, seems a bit of a stretch. The last category of payments to shareholders or directors identified on the slide is distributions and unlawful returns of capital. Distributions, of course, regulated by the Companies Act in section 930 and following, they can only be made out of profits available for that purpose. And as we all know, that's done by reference to the last accounts or the interim accounts. There are interesting questions which often arise as to whether or not retrospectively, when acting for an office holder, it's possible to allege and to invite the court to adjust, reconsider the accounts to allow for matters which ought but were not included. However, that's beyond the scope of this talk. Unlawful returns of capital, and one might add ultra-virus, I won't say too much on, but it's a useful lead-in to the case which John is going to talk about in a moment, implement. In summary, though, and borrowing from Lord Justice Mummery in the Court of Appeal in a case called Progress Properties, he said this: the common law rule devised for the protection of the creditors of a company's well settled. And he goes on to point out that any distribution to shareholders has to be in accordance with statutory procedures, such as dividends I've just mentioned, or the winding up, or a return of capital. But anything else is unlawful and ultra vires the company. So having set the scene a little bit, let me now hand over to John, who's going to address the first of the trio of cases, which is the focus of this talk. John.
Thank you, Stefan, and thank you for the introduction. As Stefan's outlined,
I suggest you unmute yourself.
I think I am unmuted, aren't I? Thank you, Stefan. Hopefully I am unmuted and can be heard. As I said, thank you for the introduction, and I'm going to be discussing the first of the three cases, which is the re-implement decision. It's a decision from ICC Judge Briggs in October. It was heard over the same days and handed down on the same day as the Vining Sparks decision by ICC Judge Jones. So query what was happening and being discussed on the judicial corridors at the time. There doesn't appear to have been an appeal from this decision. It concerned payments over a number of years through an EBT and an interest in possession trust to the directors of the company, who were the shareholders. The term that was used in the judgment was profit extraction with low tax consequences. The low tax was both for the company and also for the recipients of the payments. HMRC found the scheme to be ineffective, issued payments notices, and the company entered into liquidation shortly thereafter. In the fairly classic scenario, the claim was brought by the liquidators on behalf of the company against the directors, arguing that the payments to the directors were received in breach of their directors' duties and paid in breach of them. If we could go to the next slide, Stefan. As Stefan said, our focus today is mainly on how the payments are to be characterised and not how and why any of the schemes in question didn't work. But outlining the scheme in brief, the company created a subsidiary, which is on the slide there as S. S had two classes of shares, A shares, which had the voting rights, and B shares, which had the entitlement to dividends. The company created an interest in possession trust in favour of the company directors over the profits and proceeds out of the dividend shares. Accordingly, the scheme worked by the company recapitalising S. S would then reduce its share capital and increase its distributable reserves, thereby creating the dividend payments which would occur under share class B, and those would be received by the company directors. The scheme had the backing of a leading tax counsel, albeit the directors had not read that advice, and there had been one phone call made to a solicitor friend in Glasgow, and that was about as far as they got when it came to advice. The accounts of the company made no reference to any tax payments, and there was no provision for it to be paid either directly or as payments on the EBT and IIP. And the query was raised, well, why did this scheme exist at all? And the directors said, well, the purpose of it was to incentivise key personnel and to ensure that they stayed with the company. And the judge's query was why did you need to incentivise the directors, who were the only shareholders, to increase the value of their own property? It seemed far more inherently likely the purpose of the scheme was for the company and the directors to avoid tax. So the issues that arose in that case are on the next slide. And the first issue was, were the payments distributions, and were they ultra vires the company? If the payments were distributions rather than valid transactions and payments on a share deed under an EBT or the interest in possession trust, then there was no dispute that as the Company Act provisions hadn't been followed in any way, then as distributions they would be unlawful, which the respondent would be required to repay to the company. There was no compliance with any of the relevant parts of the Companies Act on distributions. In the alternative, the arguments were run under the Sequana line that there had been insufficient regard to the interests of creditors at the time when the company was insolvent and when the payments were made, that being the second bullet point on the slide. The third argument was whether section 423 was engaged. As it happened, the decision was ultimately decided on point one, namely that the payments were properly characterised as distributions and were ultra vires the company and not made pursuant to the Companies Act, and therefore points 2 and 3 had limited focus in either the judgment and for that reason in the presentation today. If we could go to the next slide. The directors argued that as there were trust deeds, both under the interest in possession trusts and under the EBT, those had to be accepted at face value. and therefore the proper characterisation of the payments was pursuant to those deeds and not as distributions. Therefore, the purpose of the trust scheme was to incentivise the key personnel, and the court couldn't look behind those documents unless the argument was that the payments were shams and the documents were shams. But the court said that before you look at how and whether the power has been exercised, one has to look first at whether the power existed and whether the directors should have acted in that way at all, or it would have been ultra vires the company to act in that particular way. And in taking that view, the court went back to the decision of Mr. Justice Pennycook in Ridge Securities Limited and the Inland Revenue, and made clear, reminding itself that the company cannot just take assets out of the company. There are defined methods for taking assets out of the company, either by a dividend, or it can be done by a reduction of capital or in a winding up. And the quote that is then highlighted on the slide is that they, being the directors, cannot take assets out of the company by way of a voluntary disposition, however described, and if they attempt to do so, such a disposition is ultra vires the company. Now, obviously that decision is 1964. It obviously precedes the New Company Act in 2006 and Section 39, which removes the fetter on a company acting in a way outside of its constitution and therefore lacking capacity to act in that way. That was a point that was raised in Chalcot, but obviously the decision in Ridge Securities Limited goes slightly further and picks up the point that Stefan has already referred to in the Progress Properties case, which is that even if the directors are acting in a way which is outside the strict constitution of the company, it still doesn't enable them to overcome that broader limit on their powers, which is imposed by acting only for the purposes of promoting the interests of the company. And so if we go to the next slide, in assessing that test in the Re Berens test, which you now see on the slide, addressing the Ridge Securities analysis, the court has to decide when looking at the ultra vires test whether or not a transaction is for the purposes of to further the objects of the company. Therefore, the question of characterisation arises, and the court has to ask itself a three-stage test. Firstly, is the transaction reasonably incidental to the company's business? Secondly, is it a bona fide transaction? And thirdly, is it done for the benefit of and to promote the prosperity of the company? So that test seems fairly clear. But again, the directors in that case would have asked and said, look to the documents only, and then answer that three-stage test, looking to what the documents say. In contrast, liquidators said, don't be bound by what the documents say and look to the substance of the transaction. And in looking at that question, is it just a label or is it looking at the substance? If we go to the next slide. The court said in other areas of the law, we're quite used to looking at the substance, whether it's looking at the substance of whether something is a lease or not in Street and Mountford, whether something is a floating charge or not in the Agnew case, or whether in the property progress case, whether something is properly a sale of assets or in fact a disguised distribution. And so in the rather pithy analogy that's put on the slide there, the analogy was used that a manufacturer of a 5-pronged implement for manual digging results even in a fork, even if the manufacturer insists that he intended to make and has made a spade. Applying that sort of reasoning, ICC Judge Briggs said that he was going to reject the submission that the only basis for attacking the payments made to the trust was to allege that the trusts were a sham. It is not necessary to frame the trusts as shams in order to establish the true nature of the transaction. And so the focus that ICC Judge Briggs put was on what was the true nature of the transaction, and then asking on the true nature of the transaction whether the Re Lee test was satisfied. If the Re Lee tests couldn't be satisfied, then it would be out with the company's powers, who was not made any of those payments in order to further the objects of the company. So in applying that test on the next slide, the court said, standing back, the money always came out of the company reserves, and it always ended up with the shareholding directors in sums proportionate to their shareholdings. No non-shareholder employees received the money. What was a fairly unhelpful comment in cross-examination by one of the directors was that I have never distinguished between what is right for the shareholders and what is right for the company. That was one of the reasons cited by ICC Judge Briggs in saying, in reality, this was a method for moving assets out of the company and to the directors. In substance, that was a disguised dividends, and some of the references to that in the documents before the court obviously didn't help the director's case. In substance, therefore, ICC Judge Briggs found that these payments could be properly characterised as returns of capital. They didn't satisfy the Re Lee test, therefore they were contrary to the ridge security test of promoting the furtherance of objects within the company. They were ultra vires, they didn't comply with the Companies Act, and they were unlawful, and the respondents were bound to repay them. That wasn't the same approach that was then taken in the next case, which Stefan's going to turn to now.
John, thank you very much. The next case is Vining Sparks UK Ltd. As John has already said, the judgment in this case was handed down on the same day as the judgment in Implement Consulting. Let me start at the beginning with the facts. The company in Vining Sparks was a commission agent introducing securities transactions to its US-based parent. The judgment records, and so one assumes that the evidence showed, that the costs and expenses of running the company's business were to be met and were met by the company's US-based parent. Those costs and expenses included tax, PAYE and so on, but presumably also any costs of occupying buildings and so on. The fact that the costs were met by the what is described as the company's US-based parent also suggests that the shareholder, or if not of the entire, but the majority of the company's share capital was the US company. It follows, therefore, that, and this is important in due course, there was no cause at all to doubt the parent's ability to meet those liabilities at any given time. What the company did in October 2002 is, following advice which it received from the firm Baxendale Walkers, but also others, it set up an employee scheme. The other advice I've alluded to involved a law firm, and the advice from that law firm is said to have been given on an informal basis from KPMG and also from the company's in-house lawyer. So far as the structure of the employee scheme, it went something like this. There was, first of all, a trust which was set up. That trust then had a number of sub-trusts. The sub-trust would make loans to a limited company, and that limited company would then make loans onto employees, or as we'll see in due course, the employee's family. The trustees in this case were successive companies. First of all, a company called Insiger de Beaufort Trust Company Limited, and then Herald Trustees Limited. They are described in the judge's judgment as being independent trustees. Once the funds had made their way into the trust and then the sub-trust, they were lent to Deepwater Limited at 1.5% over LIBOR, and then lent on to the employee's family at 2% over LIBOR. Now, the employees were excluded from the class of beneficiaries in the trusts. And although the trusts were discretionary, there were letters of wishes. The judgment records the employment contracts of the employees having been novated. In particular, the gross payments were then made by the company to the trust for the employees, from which in due course the employees could derive benefit, the benefit being through a loan or from a distribution in due course. In addition to being novated, the judgment describes the employment contracts as being varied, and the variation is important. It provided that the employer and employee did not have any contractual rights to receive pay or obligations to make the relevant payments. In other words, the payments of commission were also, it seems, discretionary. Now, having said that, the directors and other front office employees and the company, in fact, expected the commission payments to continue to be made, and indeed they were. Now, all of the transactions that I've just described were documented formally. There were pro forma loan agreements. There were also minutes of the meetings of directors. To fast forward the chronology slightly, the company closed in 2014. A winding up order was made in February 16, and liquidators were appointed in March 2016. At the time when the company ceased trading, no provision was made by the parent's company for any unpaid national insurance contributions or tax. In terms of the volume of payments, between October 2002 and October 2013, the company paid just over £3.3 million to the trust. The sums claimed in the proceedings by the liquidators were equated to HMRC's proof of debt, which itself was, it would appear, a calculation of the PAYE and the national insurance contributions which were due on the payments made into the trust. There was, according to the judgment, no challenge by the defendants to the quantum, or the quantification perhaps, of those payments. Now, it's important to have in mind exactly how this case was presented and what causes of action the liquidators chose. Two causes of action were put forward. First of all, a breach of directors' duties, and then secondly, fraudulent trading, contrary to Section 213 of the Insolvency Act 1986. As regards the breach of directors' duties, in the points of claim, this was cast very wide. It involved breaches of the duties in Section 172 to 176. However, by the time of trial, the case had been narrowed, or the allegations had been narrowed, so they were confined only to Section 172. Now, given the importance of the section in order to understand the judgment, and whilst I have no doubt whatsoever that all of you on this webinar or watching it afterwards are familiar with it, it provides as follows. A director of a company must act in the way he considers, and I emphasize the he in that, in good faith, and again I emphasize that, would be most likely to promote the success of the company for the benefit of its members. And then, as we know, one has to have regard to the list of other matters specified in Section 172. Now, that's the claim. It's important also to have in mind what the claim did not include by way of allegations. First of all, there was no allegation in this case of any form of breach of duty of care, contrary to Section 174. So no statement, for example, that steps taken under the scheme were negligent or the directors made mistakes, and so on, whether in the advice they received, adopting it, or implementing it. It was also not alleged that there was any insolvency at any point in the scheme's existence, and so therefore it wasn't open to the liquidators, as they might have been able to do on the basis of sequana, to say that creditors' interests ought to be preferred. It's not entirely clear, but one assumes it's because of the support of the parent company that was the factual position. In addition, it wasn't alleged that the transaction was a sham, and in due course, this appears to have formed a critical part of the judge's reasoning. So in other words, it wasn't alleged that the whole edifice was just a way of avoiding the tax and just paying the employees what they'd been having before, but simply without paying, the NIC or the PAYE. Similarly, there was no allegation that any of this was unauthorised or the company failed to ratify it. However, what there was an allegation of dishonesty against the directors, and that was levelled as follows. Although not alleged to be a sham, it was suggested that the employee scheme and the trust concealed the true purpose of what was really happening, i.e. paying remuneration to the employees. The directors knew from day one and all along, and so therefore couldn't have had a reasonable belief, that the scheme would avoid paying NIC and PAYE. And so it was said on the basis of that, and of course more than that the directors were dishonest. It was also alleged that the directors should have obtained, but didn't, obtain independent advice. So far as the defence was concerned, to complete the battleground, it was alleged that there was no breach of duty to promote the success of the company. In fact, it was said it was the reverse. The company was paying more to its employees, and so that was better and more in the interest of the company. And I suppose they might have been said, well, with paying less tax as well. By the time of trial, the claim against some of the directors had been settled on Toone in order terms, and the sole remaining director was Mr. Bernard. And Mr. Bernard said that he had acted honestly, reasonably, and he relied on the advice that he was given by professionals, and moreover that he was transparent with HMRC at all material times. Next, it was said that the company's parents had authorised, acquiesced, or ratified the actions, and so they couldn't be breaches of directors' duties. Furthermore, that limitation was against the liquidator in respect of the transactions which were older than 6 years. Causation, a point was also taken, although it's not entirely clear because it's not fleshed out in the judgment how that point would work. One would infer that what was going to be said was that the transactions did not of themselves cause loss per se to the company, although of course there's little doubt that they would have caused loss to HMRC. And then finally, the usual defence one finds that the directors acted honestly, reasonably, and should therefore be excused. As I think is well known, the liquidators lost this case against Mr. Bernard. And of course, what's interesting about it is why the claim failed. What you now see on the slide is pretty much the opening lines of ICC Judge Jones's judgment. He starts by saying, every man is entitled, if he can, to order his affairs so that the tax attaching under the appropriate acts is less than it otherwise would be, taken from IRC and the Duke of Westminster. And that gives you some immediate clues, or at least the reader, as to how ICC Judge Jones was approaching what I like to think of as the tension between tax law and company law on the one hand and insolvency law. You might as well summarise it as being that if you can pay less tax, why should it be a breach of your director's duties to arrange the company's affairs to pay less tax? Now, at that point, it might be said that the reasonable person would think, but hang on, the whole thing is artificial. It has been deliberately set up to avoid tax. In reality, what was happening was that the same employees were getting the same amount of money, in fact, more than they did before. All that changed was that nothing was being handed over to HMRC. Now, of course, at this point, it's important to recall that there was no allegation that the whole thing was a sham. So in other words, one had to work, at least as a starting point, from what the documents provided, i.e. payments, discretionary payments to the trust, and then loans by Deepwater to the employees, but no payments directly from the company to the employees. Now, in the absence of an allegation of it being a sham, it's difficult to see why that approach is wrong. Now, of course, in a case of breach of director's duties, it's important to have in mind the frame of mind of Mr. Bernard at the relevant time, because it is his actions, acting in good faith, whether he believed, whether it was in the interests of the company. Now, was that something which could be fairly laid at his door when the scheme was set up? And that, of course, depends to a large extent in this case on the judge's findings as regards Mr. Bernard's evidence. Now, the judge had evidence from one of the liquidators and in the usual way said that he had been assisted, but that the liquidator's testimony was not personal testimony and it was inevitably hearsay. Of course, the important evidence was Mr. Bernard's evidence. The judge included in his judgment the usual reminder now taken from Mr. Justice Leggett's judgment in Guessman as to the fallibility of memory. And he made the point that Mr. Bernard was being asked to give evidence in relation to events which occurred before 2010, and in fact in relation to certain key facts which had occurred in 2002. Allowance made for all of that, he found that Mr. Bernard was an honest and helpful witness. He said that he was serious, considered each question carefully, and in the judge's judgment sought to provide truthful answers. Insofar as there were issues concerning his recollection, the judge was satisfied that they were attributable to memory problems rather than anything else. In other words, Mr. Bernard was not found to be dishonest. In cross-examination, Mr. Bernard had accepted that the employees would be paid commission through the trust, even though indirectly, and even though the entitlement was discretionary. But had it not been, there would have been questions for the trustee. He also accepted the company's underlying intention was to remunerate its employees, and the commission was the only emolument, but that it was trying to avoid tax and national insurance. And it might have been thought that with those sorts of concessions in evidence, that Mr. Bernard would be banged to rights under Section 172. However, at this point, it's necessary to point out that, as the judge found, the context of all of this was that Mr. Bernard had been advised that the scheme worked. And even if he realised that the scheme involved certain artificial steps, that was nonetheless the advice that he had had. That means in due course it was necessary to scrutinise very carefully the advice that Mr. Bernard had received, not just at the start, but also as the scheme was used from 2002 to 2013. The judge was satisfied, even though no evidence or no written evidence had survived of the advice which had been given, that the company had been told that PAYE and NIC would not be payable. He was satisfied that client procedures at Baxendale Walker had been followed and that they did advise on the scheme. As regards the other sources of advice, he placed less emphasis on those, not least because, for example, in the case of Miss McCormack, who wasn't called as a witness, the in-house counsel, she didn't have the necessary expertise. The law firm that advised wasn't formally retained, and KPMG were advising the parent. Now, the liquidator, as part of their attack on these transactions and this trust, pointed to a number of incidents which occurred, admittedly, after 2002, but which meant that the directors ought to have realised at that point that the scheme was going to fail. So, for example, it was said that Mr. Baxendale had been struck off. And surely at that point, it's right to say that Mr. Bernard realised that the scheme was going to fail. However, Mr. Bernard said he thought in evidence that the striking off was to do with a false reference and nothing to do with tax. A number of cases were decided during the course the scheme was being used, for example, Dextra, which found that for corporation tax purposes, the deductions of payments were valid. In other words, the scheme worked. Now, that was advice which was given to Mr. Bernard, although no advice actually read Dextra. And even when, in due course, Dextra was overturned by the Court of Appeal and by the House of Lords, the advice which Mr. Bernard received from Baxendale Walker was that, in fact, this was enormously positive because it meant there was no own goal by HMRC, in as much as they'd failed to challenge the trust. HMRC did, of course, contact the company in 2004, 2005, and 2008. But at all of those times, the company continued to be advised by Baxendale Walker, and the advice it received was that the scheme worked. An employee, or rather the accountant of an employee, challenged the scheme in 2006. The accountant saying, well, surely this is just disguised remuneration. And Mr. Bernard was advised by Baxendale Walker that as long as the beneficiary of the trust was a family member and the employee was excluded, the scheme worked. The company's auditors didn't give any material advice on the scheme, at least in 06 and then 07, although the position changed in 2008. And when in 2008, HMRC started serving notices on the company, and of course the company appealed, it seems, and a humorous line in the judgment, is that the company was advised by Mr. Baxendale Walker to not worry too much about supplying the information to HMRC in the right order, and to perhaps drop the file on the floor and shuffle things around before it was sent. Of course, ICC Judge Jones says that was plainly not acceptable, but one couldn't extract from that that the whole structure since 2002 was wrong and was going to fail. In reality, it wasn't until the Rangers case in 2012 in Scotland, and even then at first instance and in the upper tribunal, both times the taxpayer succeeded, and in 2015, when it was overturned, and in due course 2017, that it became clear that the trust did not achieve its aims. However, where does that leave us? Well, as Judge Jones concluded, an ineffective scheme, even one which has artificial features, did not necessarily mean that the scheme was dishonest. And perhaps to quote from the judge's judgment, he said in paragraph 150, that it wasn't for the court to contradict the decision of the director, who had reached and acted upon his own decision in good faith, believing it to fulfill his duty to promote the success of the company. The court addresses the mind of the director. It does not ask whether in fact the steps taken were in the best interest of the company to most likely promote success, etc. He went on to say he accepted Mr. Bernard's evidence that he believed the employee scheme on the basis that it worked because the payments of the trust into the subtrusts and as loans were not contractual entitlements. He relied upon the advice he received, and he was not dishonest for doing so. Although it's fair to say that he was criticised, Mr. Bernard, that is, for not getting independent advice from somebody other than Baxendale Walker, who were connected with the scheme and setting it up, the failure to do so did not mean that the scheme was dishonest or that he was dishonest. Moreover, Mr. Bernard's evidence in cross-examination and the documents did not also suggest that he was aware that the scheme was dishonest. Neither did, for example, using letter of wishes, which, although artificial, was part of the scheme. In other words, the claim failed because the judge was satisfied that Mr. Bernard had relied upon the advice and had acted honestly, and that in hindsight, although of course by 2017 it was possible to know the scheme failed, that wasn't, at least the judge found, obvious in 2002. I mentioned earlier the defences which were open to, or rather which were run. I don't want to say too much about those, but we'll just add that if dishonesty had been established, then the defences of acquiescence and limitation would have failed. Nothing, however, was said about causation, so that's not addressed in the latter part of the judge's judgment. And moreover, the judge concluded that he would have needed more information to make further findings of fact to decide whether or not Mr. Bernard should be relieved. So all in all, an interesting case, but a defeat for the liquidators. So I think that means it's 1-1, and we now come, John, over to you, and to consider the decision in Chalcot Trading.
Thank you, Stefan. So the third case that we're looking at came in May of this year. And if we go to the next slide, then you'll see it was a decision of Michael Green QC, sitting as a deputy in the Chancery Division, and the decision is currently being appealed. If we go to the slide after that and the facts, this case is slightly unusual in that the company was solvent, and it was an action by the company against HMRC and the directors, albeit the company was still acting by those directors, or at least one of them, at the time of the decision, to argue that what they had previously said was remuneration were in fact and in substance distributions. So despite the fact that they had entered into a fairly complicated remuneration scheme by E and F shares, which I'll go on to explain in a moment, and put it into the accounts and created trust deeds and documents which said that this was a remuneration scheme, because the scheme had been found to be ineffective, or at least was being challenged to be ineffective by HMRC, the directors had decided to turn around and say that actually, in substance, what they had been doing was paying distributions to themselves. They hadn't complied with the Company Act, and therefore, in substance, what they had been doing was carrying out unlawful distributions. Evidently, because the directors had carried out that sort of volte-face on what they'd previously been telling the court they'd been doing, they were treated with a degree of scepticism. But the directors said, notwithstanding that we're in a slightly unattractive position, you go back to the approach taken in re-implement and you say, look at the substance of the transaction. Is it in substance a distribution? If so, it is unlawful because it hasn't complied with the Companies Act, and we should therefore find that the whole scheme is null and void, and the payment should be reversed. The scheme worked by creating classes of shares and new articles of association, which were E and F shares, and in exchange for subscribing to those newly issued shares, the directors were given rewards through increases in their loan accounts and credits on those loan accounts. There would be a call if they left the company, but the whole purpose of it was some form of remuneration to keep the key personnel. Under that scheme, which they said was remuneration, they received profits directly from the company. They received about £6 million worth of profits, but also it reduced the liability of the company overall. But it was not plainly and straightforwardly remuneration, and so therefore the argument was the tax wasn't going to attach to it. HMRC challenged the validity of the scheme, and the company then decided that actually the whole scheme hadn't been such a grand plan as they originally thought it to be, and so decided to challenge it and say that in substance, despite previously having been called remuneration, it was in substance actually a distribution. If we go to the next slide. So the first question the court had to decide was whether or not these payments were distributions or remuneration. And as I said, the main argument that was being run by the company, the solvent company, was that re-implement should be applied to this solvent company, and it should be a substantive analysis of how the payment should be characterised as distributions or remuneration. The alternative arguments which were then run, and we're not going to focus on in a huge amount of detail, whether or not the payments were, even if not unlawful distributions, then unlawful discounts or commissions contrary to section 552, 553 of the Companies Act, or in the alternative, as D and F share schemes were created on the basis that they would avoid tax, whether the agreement should be set aside on the grounds of mistake when it turned out that they didn't have that effect. However, the primary focus today will be on the first issue on the slide, whether the payments were distributions or remuneration. In any event, all of the claims by the company failed, and therefore the directors were found to have actually paid themselves remuneration. What the court didn't decide to do was follow the approach that had been taken in Re-Implement. They didn't think it was a simple question of ignoring the substance and looking to the label of the transaction. But equally, they said the test was not by applying the Re Lee test we looked at earlier, but instead the question that had to be asked was whether there had been a genuine exercise of the power to award remuneration by the directors. As I said earlier, the three tests in Re Lee, which are on the second bullet point on the slide, are whether the transaction was reasonably incidental to the carrying on of the company's business, whether it was a bona fide transaction, and whether the transaction was for the benefit and to promote the prosperity of the company. And of course, if all of those three questions could be answered yes, then the transaction would have been to promote the purposes of the company, it wouldn't have been ultra vires of the company, and therefore the transaction wouldn't have been set aside on that basis. If, however, in the alternative, the answer to those questions was no in Re Lee, then you would query whether or not the payments was within or were within the ultra vires powers of the directors, and whether therefore they should be challenged and set aside. However, in the next slide, you'll see that the court in Re Chalcot decided that the tests in Re Lee weren't particularly helpful and shouldn't be followed. And the analysis they took was by turning to a judgment of Lord Justice Slade, this is the third bullet point on the slide, and saying that the Re Lee tests should, in my opinion, now be recognised as being of no assistance and indeed positively misleading, where the relevant question is whether a particular gratuitous transaction is within the company's corporate capacity. The response of the directors to that was to say, well, that approach was taken in Toone and Re-Implement, but that approach also didn't hold much sway with Michael Green QC. He said that the Re-Implement decision, this is the second bullet point on the slide, didn't appear to have involved any consideration as to whether there was a genuine exercise of the power to award remuneration. He also pointed out that in the Chalcot decision, the challenge to the payments that had been made to the directors was primarily on the statutory basis, and the idea that if it was contrary to section 830 of the Act, then it would be ultra vires on that basis, whereas in the Re-Implement decision, the basis on which the challenge was made was slightly wider, both by not complying with section 830 of the Act, but also not complying with the common law broader doctrine of only acting for the company's purposes and to promote the company's purposes and not moving assets out of the company by way of a gratuitous disposition that didn't comply with the relevant Companies Act rules. In any event, in Chalcot, the approach of Michael Green was to say, before you go back a stage, Stefan, sorry, one stage forward should be slide 27. The approach of the judge was to say the ultra vires doctrine doesn't appear to be as clearly in play when you're looking at questions of payments to directors. And the reason that the judge found that it had been abolished was the enactment of section 39 of the Companies Act. And I'll set out that provision in more detail later, but as I summarised earlier, it is that provision which says that ultimately an act of a company is not going to be invalidated by something within the company's constitution. So having decided that Re Lee was not the test to follow, the judge adopted the test which is at the last bullet point on that slide, and the question should therefore be whether the transaction in question was a genuine exercise of the power to award remuneration. And that comes from the Holt Garage test by Mr. Justice Oliver back in 1982. And if that test is taken further on the next slide, the test is not a purely objective test, but will involve looking to what the directors actually thought and decided. And in deciding whether or not there had been the genuine exercise of that power, there was going to be a margin of appreciation allowed to the directors, and it was described as being a wide margin of appreciation. The court in Re Chalcot seemed particularly reluctant to engage in any sort of analysis on how excessive and how extreme the remuneration would be before it was in substance decided to be a distribution paid to the directors. And so on that basis, the wide margin of appreciation prevented the court from going in too much detail into that analysis. It's entirely declined to follow the decision in Re Toone for the reasons that I've already mentioned. But the other reason that it said the Re Toone wasn't going to really help, that's the implement decision, was because ultimately in re-implement, the company was insolvent, and therefore there was a factual difference between a solvent and an insolvent company. Now, query whether that should cause as much of a difference between how you characterise the decisions and the payments to the directors that was taken between those two cases. If you go on to how the Chalcot test was applied and that wide margin of appreciation, the court said that ultimately the purpose of the scheme in this case had always been described as being remuneration and avoiding tax liabilities. So it's closer to the Vining Spark analysis on that point. The documents had always referred to it being employment related and not to be a distribution. The accounts had also recorded it as remuneration and again not being a distribution. And although the argument that was made by the company in that case was that if you looked at it and you said, well, it looked like a dividend because it was paid in the same proportions to the business profits and the shareholdings that had arisen in a particular year, therefore you should hold that it was properly a dividend to be paid and not a remuneration question. The judge said ultimately that doesn't affect the analysis too much. Just because it is paid and it looks like a dividend doesn't mean that in substance it is. The other question that was raised by the company in that case was that even if you subscribed to shares, there wasn't a fair exchange of value between the directors who were subscribing for the shares and the company paying out those profits in response by way of the rewards on the share scheme. Because, so the company argued, if you were increasing the share capital, you were essentially increasing the liability of the company. What you were not doing was increasing the distributable reserves. Accordingly, the court looked at it overall and said that the payments at the time had been properly characterised as remuneration at the time, and there was no need to reverse that. And as I say, the difficulty with that case was that it was essentially a case of very hard facts. The judge decided that it wasn't going to be in the position of removing the remuneration which had been given to the directors if that purpose was to effectively remove the tax that the company was going to have to pay, and that the directors had entered into a scheme in order to, in large part, avoid. And if we move on to the next slide, in the query with that decision, as I said, there was a large rejection in that case of the approach in Re Lee and the three-stage test, and that was based on the judgment that came from Lord Justice Slade in Rolled Steel. And if we could go back 3 slides, if you go to the 3rd bullet point on that slide, you'll see the decision of Lord Justice Slade said that the Re Lee tests should, in my opinion, now be recognised as being of no assistance and indeed positively misleading when the relevant question is whether a particular gratuitous transaction is within the company's corporate capacity. That was the quote that was put into the Re Chalcot decision. But if you go forward 3 slides, what wasn't quoted in Re Chalcot was the line that Lord Justice Slade then went on to say that to this extent, the 3 tests should, I think, finally be laid to rest, though they may well be helpful in considering whether or not, in any given case, the directors have abused the powers vested in them by the company. Now, if you take that second line of the caveat to the removal of the Re Lee tests that Lord Justice Slade set out in Rolled Steel, you could actually say that the 3 tests should have been looked at in the Chalcot analysis, because the question the court was having to look at was whether or not the directors had abused the powers that had been vested in them by the company. And therefore, that was the caveat that the Rolled Steel decision had said while laying the 3 Lee tests to bed. Also, it's slightly difficult to say that Re Lee tests have to be abandoned altogether, which is the second point on the slide, which is the Court of Appeal's approach in Macpherson and the European Strategic Bureau Limited case. The approach in that test is far closer to the re-implement decision and there is reliance and express use and following of the Re Lee tests in deciding whether or not remuneration had been paid in an ultra-virus way. And there's not the sort of analysis that's taken in the Chalcot decision, which is to say that ultra-virus is not a particularly helpful analysis to go down, and that ultimately it shouldn't play much of a role given the enactment of Section 39 of the Companies Act. And you'll see Section 39 at the bottom of that slide anyway, and it's the well-known provision that the validity of an act done by a company shall not be called into question on the grounds of the lack of capacity by reason of anything in the company's constitution. And it was that provision which led Michael Green QC to say in the Chalcot decision that ultimately ultra-virus was not going to be of a huge amount of interest or importance when characterising transactions. Now, you might say, and I think it's probably easier to say, that Section 39 is there to protect third parties from the risk of entering into a transaction with a company which is later invalidated due to something in the company's constitution of which they were unaware. Query whether that provision can actually be used and invoked in order to allow the directors to move capital and money from the distributable reserves out of the company and to themselves without following the proper provisions within the statute and other parts of the Companies Act. So I think there are queries that can be raised with the Chalcot decision, but overall it might be a case in which you say there are very hard facts, and the judge decided that although the approach was seemingly harsh towards the directors, ultimately he was going to follow what they had said in the document and describe it as remuneration rather than the distribution of distributable reserves. And so if we go on to the next slide, I think we're at the general concluding thoughts stage.
John,
which Stefan is leaping back in.
John, thank you very much. Well, just to say that my own thought of this, and I know, John, you were going to sort of talk to the first bullet point on this, but my own thoughts, having heard what you've said and contrasting it with what I've said, it's difficult at this stage to draw firm conclusions because the three cases are on pretty different facts. Whether that's because the recipient of the relevant payments were or weren't shareholders, or because of the insolvency or not insolvency scenario of the relevant company, and moreover because the causes of action which were maintained by the claimants in the cases on the whole are different. However, John, you considered Implement and Chalcot, and both of those adopted similar causes of action. Have you got any thoughts? If you were to be told which one should be preferred, which of those two decisions is likely to be followed?
Well, as I think we've said on the slide, which sort of hints as the answer to that, I think it is more likely that the Implement decision is going to be followed. And that's largely because, in my view, it's closer to the approach that was taken in Macpherson, and the grounds for departing from the Implement and Macpherson approach, which is to say there's an ultra-virus analysis which requires looking at the three Re Lee tests and asking whether or not the payments were properly construed for the purposes of promoting the company's interests. If you look at that sort of analysis, that's got a stronger heritage within the case law than the approach that Michael Green has taken, which is to sort of stop the analysis and to say, well, what have the directors said? Should we characterise the payments in that way? The approach of Insolvency Court Judge Bridge is to say, well, stand back, look at the process first, look at the payments, characterise the payments, and then see if that can be reconciled with any approach that has been taken by the company directors. So there's a slightly different standpoint between the two decisions, but I think if you're going to make a contrast between them, I think the Implement decision is likely, both on the basis of previous authority and also in principle, to be the approach to be followed.
Thanks, John. So two thoughts from me. First of all, it is to really, and circling back to where we started the webinar, the three cases that we talked about all had pretty different causes of action, and that really, in my view at least, re-emphasises the importance of correctly characterising and identifying the transactions, the recipients, and so on, and then choosing the right cause of action. It might be said that in Vining Sparks, it was the wrong course of action which was chosen, and in fact, Judge Jones at several points in his judgment makes that observation, but going on to say, without meaning that it should have been presented differently. But it's noteworthy, for example, that there was no allegation in Vining Sparks that any part of the transaction infringed, for example, Section 423 of the Insolvency Act. Whether it could have been classified as an unlawful dividend, given that the payments did not go to shareholders, it is easier to see why that wasn't done. That brings me to the second point, and I alluded a little earlier to it lurking in the background, which is setting the case of EBTs. What I think of as a fairly difficult interplay between, on the one hand, company law and insolvency law, and on the other hand, tax law. And in fact, maybe Section 423 is a good example or a good lens through which to view this. Of course, we know Section 423 envisages the courts unwinding transactions which are entered into for one of two statutory purposes, the second one of which is to prejudice the interest of somebody who is or may make a claim. Now, of course, the revenue is very much such a person. And so it might be said that the very fact of entering into an EBT, which is going to result in less tax being paid, might be something which comes within that limb. And this is where the tension arises, because it's, I think, important to have in mind the possible distinction between what is mitigation, avoidance, and tax evasion. And if one looks at tax cases, there are all sorts of definitions, but for example, evasion being something which is illegal and criminal, avoidance being legal but unacceptable, and mitigation being legal and acceptable. So that poses this question, which is if something is going to be labelled as, say, mitigation, so yes, HMRC are going to receive less money, but it's perfectly lawful under the Tax Act, how could it suddenly become unlawful under, for example, Section 423, or as a claim to breach of directors' duties? The line is much harder to draw when it comes to tax avoidance, because in the case of tax avoidance, one is using artificial elements. And so we can see how it might be that it infringes Section 423. As I say, these are questions which arise, in my view, in EBT cases, and the trio of cases that we've just gone through, John and I, don't necessarily give you the answer, but it is a tension which is in the background of these cases, and I don't believe has yet been clearly resolved. Those are my two final thoughts, and subject to John wishing to jump in with anything else, it remains for me to say thank you to all of you who have watched this webinar live and who may in due course watch it on the Chamber's YouTube channel. What I propose is that John and I will stay in the Teams meeting for another couple of minutes if anybody wants to ask any questions to us via the chat function. And if after a couple of minutes there are no questions, we will sign off. So thank you very much to all of you for joining us.
Thank you, Stefan. Can I just repeat the thanks to everyone for joining? I don't think we have anything in the chat function at the moment, apart from people heading for the door. But if anyone does have any questions to ask, then do by all means post them there.
John, you may see we have a question from Anton Smith, who asks this: do the cases adequately address the fact that the EBT is a legal entity and the first recipient of the funds is not the director or shareholder? I apprehend that's more a question for you than for me, but let me just answer by reference to Vining Sparks, which I covered. In my view, Anton, it does, or at least Vining Sparks, because the starting point was that the transactions had to be taken for what they were. There was no allegation that it was a sham. And in concluding that Mr. Bernard, the director, didn't breach any of his duties, that has to have been on the basis that the transactions were valid. They were to third-party entities, which enabled Mr. Bernard to say, well, I was advised and told that as long as we paid the trust and the trust then paid a loan, it wasn't remuneration. So I think by reference to Vining Sparks, the answer to your question is yes. But John, do you have any thoughts having in mind implements and Chalcot?
Well, I think on Chalcot, Chalcot wasn't strictly an EBT case. It was more a case in which the payments were made when shares were issued, and it was a reward for the payment of shares. So it wasn't that separate entity of a trust that sort of stood between the directors and the company. In the implement decision, the EBT existed for part of the payments and the IIP existed for the other part. And although it did stand as a legal entity between the two, it was the judge's analysis that if you looked at the substance of it, there was in fact just a distribution from one to the other. And it's that sort of harder substantive analysis that breaks down the independence of the trust in between the two that was conducted by the court, not going down the sham analysis, but saying that if you looked at the substance of it, there was in reality a movement from one body, i.e. the company, to the directors, and the stages in between didn't do enough to break that chain. So hopefully that answers the question. I don't know how many we have. I don't think I've seen Anton Smith leave.
Thanks, John. I think that was the only question, but let's maybe give Anton an opportunity to respond to that. So Anton's come back saying that he was thinking more of the EBT being the respondent to the claim. So I know from my own practice, a case that I did a while ago called Nikovsky, that in that case, the respondents to the claim by the trustee in bankruptcy were the trustees of the relevant trust. It wasn't an EBT, but it was a trust. Now, having said that, it's necessary to identify the relevant cause of action with care here, because in that case it was 423, so perfectly proper to go for the respondents to the transaction. In the case of Vining Sparks, the target of the transaction was the directors, because the cause of action was breach of directors' duties. Had the liquidator wanted to go down the 423 route, it would have been necessary to sue the trustees. John, I don't know if you want to add anything to that.
Yeah, I think it's worth pointing out, and I think all the decisions that we've looked at, the way the causes of action were framed was primarily against the directors, and it wasn't putting the EBT as a respondent in any of those. So to the extent that you attack the EBT in that way, these decisions are probably not terribly helpful if you're looking to make the EBT the respondent.